Just out of curiosity, how many of you here in the room, and you guys don't get to vote, have had a first-hand experience dealing with an ombudsman? Half a handful. You're not uncommon. And my role today, in some ways, is to be your proxy. I didn't write the preeminent book about the Organizational Ombudsman, Origins, Roles, and Operations, a Legal Guide. The ABA published this a year ago, January. He did. I have never run two of the signature Organizational Ombudsman programs in the United States, perhaps in the world. He did. But, and a slight correction to what Evan said, for close to 30 years, I focused on corporate leadership issues as an executive search consultant. And as the years went by and more of the work got up where I was dealing with board members, my focus shifted from leadership towards governance. And I started to ask board directors, what keeps you up at night? What really bothers you? And the words I got back were different often, but there was a common denominator. I'm terrified of what I don't know. So here we have a cohort of directors who are terrified of what they don't know. Started reading Ethics Resource Center and KPMG survey results. In grossly generalized summary, they found that between half and 3/4 of the employees of any given large company in any given year saw at least one instance of bad stuff, of malfeasance. And of that cohort, 1/4 to 1/3 said nothing. They were locked in dangerous silence. They were afraid. They didn't know who to go to. They didn't know what to say. They didn't want to look stupid. They didn't think anybody would do anything if they did. And they feared retribution or retaliation if they spoke up. So they were locked in what I call dangerous silence. So you've got this cohort that knows stuff. You've got this cohort that's terrified of what it doesn't know. How do you marry the two? Well, Sarbanes-Oxley legislation, New York Stock Exchange, NASDAQ, OMX, even the US sentencing guidelines either mandate or encourage, incent companies setting up channels of communication their employees can use without fear of retaliation. In response to that mandate, they set up channels such as an ethics office, compliance office, human resources, employee assistance, internal audit, risk management, legal, chief CFO's office. You draw a line, a mental line, under each of those channels in the company. For discussion purposes, they are formal channels which will define as they are agents of management. They make policy, they enforce policy, and they keep records. As well they should. It's illegal for any retribution if someone goes to them and reveals malfeasance. But this cohort over here doesn't believe that. So they don't go to them. They stay locked in dangerous silence. Now that mental line you have with all the formal functions above it, drop down below the line. That's where the Organizational Ombudsman lives. What makes it different, it's informal, not agent of management, does not make policy, does not enforce policy, and does not keep records. Done right, the office will have a policy for getting rid of records as soon as a project is done, so there's nothing to be discovered. Done right, and Chuck will speak more to this, the office can claim privilege under certain circumstances to be certain that conversations with the Ombudsman's office are not revealed. The presence of this Ombudsman tends to shift the culture. When an organization has just those formal channels, they've ticked the boxes that they're supposed to. They have a culture of compliance, and people don't believe. When there is an ombudsman present, and if it has been understood, rolled out, and made its presence known appropriately, you have a culture of trust, culture of candor, and a culture of accountability. That's a big shift. The context has shifted. The same sort of content goes on in the company, but the mindset of the people who are there shifts and is freed up because they know that leadership, both management and the governing body, wants them to have a voice. It's that organizational ombudsman function that we're going to talk about today. I want to turn it over to Chuck to pick it up and sort of go from there with details.
Hi, thank you very much. I have some handouts of a PowerPoint here. We're not going to do a PowerPoint, but there's a little outline that I'm going to refer to. If you don't have a copy of that, feel free to try to get a copy of that because it'll make it easier to follow what I'm going to say. But I have two tasks. I'm going to tell you what an organizational ombudsman is and why it may make sense to have one. And I say that in the context of this word ombudsman is a very elastic word. It means lots of things. It's like organic. You know, you say it and mean one thing and somebody hears it and thinks another. And that's because it has a long history of actually morphing over time. It began in Scandinavia and Sweden in 1713 as the king's representative. It then, about 100 years later, was established by Parliament. And at that point, it was an investigator and a prosecutor. So it was a highly esteemed lawyer. And that was the role. It was really kind of like a special prosecutor or an inspector general for that. It came to the United States only in about 1961 as a result of a law review article by a very prominent administrative law professor, Kenneth Culp Davis, who had taken a sabbatical, traveled the world, and reported in this law review article that he was looking for ways to solve interesting administrative law problems. And the one he found most interesting was the Scandinavian concept of the ombudsman. And he actually predicted that that would be adapted in the United States for our own particular purposes, and it has been. And so as you hear that word today, keep in mind that it covers three basically different types of practices, and this is a result of some ABA resolutions that were adopted that kind of categorized it. There's the classical ombudsman, which is the government official often having subpoena power or statutory confidentiality that investigates and issues reports. We're not talking about that today. There's another kind of ombudsman that's really called an advocate ombudsman that has a constituency that speaks on behalf of a group, and nursing home or readers representative ombudsmen are representative of that kind of group. We're not going to talk about that today. What we're going to talk about is the organizational ombudsman. And in a sentence, and you'll see this in the handout, it's an independent, neutral person with whom an employee or coworker, or by the way, you have two here from Stanford. Stanford has an ombudsman, David Rash, right here, and Stanford Medical School has an ombudsman, Martha McKee. So there are two traditions of this evolution for ombuds, one in the academic setting and one in the business setting. And so when I say worker or employee, it also applies to student. But it's an independent, neutral, confidential, informal resource that you can go to. So the problem with many of the places where you could otherwise go is that they are record notice channels for an organization. Here, it's set up to be independent. They report to a senior manager or senior administrator. They are informal. They don't keep permanent records. They are neutral. They are not designed to be an advocate for administration, for management, or for employees or students. They are designed to be independent, neutral. And I've given on the handout some lists of things that ombudsmen do and some things that ombudsmen don't do. And the key thing about what they do is that they are a source of information and guidance. Before you have to go or before you decide to go to a place like a dean's office or an HR or a compliance program or a place where if you report something they have a duty to investigate, you can get some advice, you can get some information, and sometimes just getting the information is a very sensitive issue. Where do you want to, how can you get the policies on transgender, for example? I mean, there are a whole series of things where just getting the information is very tricky. Plus, what is the process? What will happen if I do this? That's what the Organizational Ombuds does. They are not a shadow compliance office. They're not a shadow HR. They don't do investigations. In the literature that we have, the brochures, the charters that help establish the independence, we say they do not have authority to accept notice of claims on behalf of an organization. So they're there as a supplement, and that's a key point. So why would you create one of these? And I'm going to cover a lot of ground here. We don't have a lot of time, but I'm going to do it at a fairly high level, and there's a bunch of data that supports all of this. But the way I've envisioned it is like a pressure cooker. We have this bubbling, stewing pot of who we are, how we've changed, and how we work, and how our work has changed. And on top of that, you have pressures from the law. And I'm going to go through each of those. And then the third element here is, what is the mechanism to escape the pressure? And are those mechanisms working? So let me take them on one at a time. You'll see the first slide that I have is changes in the workforce. And again, there's a lot of data that supports this, but with the role of immigration having essentially surpassed or coming close to surpassing and soon surpassing that of the late 19th century, early 20th century as a percentage of population, who we are has fundamentally changed. One study said if you consider the 30 million immigrants and their children, 1 out of 5 Americans has their roots in another country now. That's a fundamental difference that flows through in culture conflict. It flows through in demographics, racial. It's in 1950, the United States was 90% Caucasian. In California, among other places, it's less than a majority, and nationwide it will be less than a majority. Hispanic population has increased, the Asian population has increased. All of that breeds conflict. You add to that, the baby boomers, my generation, if you will, are no longer in charge everywhere. They're certainly no longer the majority. In 2010, the millennials, the X and the Y generation, actually became the major force in the workforce. So you have the generational difference. You have the role of women. Women are outperforming men at every level of educational achievement. And with the recession, you have the construction and the manufacturing sectors where they've shed workers. And so women may actually now be the majority presence in the workforce. That all leads to conflict. That's that stewing, bubbling pot that I'm talking about. Okay, the next slide is, what are the changes in how we work? And that's a remarkable change as well. One of the statistics that I found said that 100 million Americans are working remotely or work with people who work remotely. So we're electronically connected now in ways that we never were before. And with that comes a whole series of other changes, including kind of worker alienation. One of the quotes that I thought was just a very interesting quote in last month's Economist of September 10th was, after decrying how difficult it is to find knowledge workers, people are crying for jobs, but companies are crying for knowledge workers. They go on to say, finding the right people is hard enough. Keeping them motivated once they are on the payroll is even harder. Surveys suggest that about 4 out of 5 employees would leave their current job if they could, but most think that they would have trouble finding another one at the moment. A global Gallup survey found that at the average big firm, only 33% of employees described themselves as being fully engaged, 49% say they are not engaged, and 18% say they are actively disengaged. That's the new work relationship. There's less loyalty from companies to workers, there's less loyalty from workers to companies, and part of the change in how we work is about 25% of the workforce is now no longer an employee. It's a non-standard work relationship of contract or part-time or contingent. I mean, that's how it's changed, and it's global. Even if you have a company of 5 or 10,000 people, you're dealing with cultures from all over the world, and many companies that are big companies, deal with, in fact, people, workers from all over the world that are linked together only electronically. So that's the pot, if you will, the bubbling, stewing pot, who we are and how we work and how it's changed. Now let's talk about the law. And again, I'm skimming over a lot of this. I'm happy to answer questions, but we all know, we've heard the words Sarbanes-Oxley, we've heard Dodd-Frank, we've heard, maybe you haven't, but the federal acquisition regulations for a lot of companies that do business with the government have mandatory disclosure. I was involved in a group from 2002 to 2004 that helped revise the federal organizational sentencing guidelines. You know, the whole compliance industry came about as a result in 1991 of the federal organizational sentencing guidelines. So you have all that regulatory pressure on companies to act responsibly. And part of what I have tried to do is I track the law from employment, from criminal law, and from corporate governance. And from each of those different threads, and they all are very different, they've all converged, in my view, to require companies and organizations, and it's not just companies, to create standards, codes of conduct, to investigate properly, can't sweep it under the rug anymore, and to take corrective action. You have to punish the wrongdoers, you have to fire people, you have to act. All of that puts an imperative on organizations to act. And I think in so doing, it raises the barrier to people coming forward, because before you're going to go to one of these reporting channels and turn on this kind of machine that grinds up people and does an investigation, you want to know what's going to happen. What is the process? And it gets very tricky, but that's the pressure. So now you look at, okay, how have companies been dealing with this? And this is the third element of my why you create argument. Excuse me, and I think there are three kind of current standard best practices. You know, companies have beefed up their training and their requirements, the professionalism, quote unquote, of compliance, HR. They have trained their supervisors that they have a duty to act on behalf of the company. I'm sure all of your professors here at the law school have been given training that if matters of sexual harassment come to them, they have a duty to report it. I mean, that's the new world that we live in. So what's the downside of that? I mean, that's one aspect. Let me get to the downside in a minute. Another way is hotlines, you know, 1-800 call-in numbers, and a third way is the whistleblower laws and policies. But if you look at each of those kind of best practices, all are driven by an assumption that they are top-down. There's a silo. If you have an HR problem, you go to HR. If you have a student problem, you go to the D. If you have a compliance problem, you go to the compliance officer. If you have a work performance problem, you go to your boss. But if you're in the bottom looking up, I'm not sure that you always see it as HR or compliance. You know, maybe you just have a problem with a coworker. Maybe your problem with the coworker also involves the coworker cheating on the timesheets. So it's not as simple as that kind of silo approach to things. And when you look at the data on the effectiveness of these kind of methodologies for dealing with these problems, I think they leave a gap, and that's where the organizational ombuds comes in. So let's talk about management. You know, as John said, their ethics resource center surveys, about 40% of the misconduct is not reported by anyone. Year after year, it goes up and down a little bit, but there's a major element of people who won't come forward to report. And why? Because those formal channels, the ones that John listed that are above the line, those are all formal channels. They're like the police. You go to them and they have to act. And so if you're not ready for them to act, you can't really go to them. Because of the professionalism, they can't say, well, I'll keep it confidential and off the record for a while. So I think one of the very primal structural elements in our society and the way we view the world is that we look for checks and balances. And I've quoted Abe Lincoln a lot. You know, I think it's a good quote, but he says, you know, you can't dip clear water out of a muddy stream. And so the people that you have populating your organizations may be good, may not be good. They may be partially good and partially not so good. They may have mixed motives. And so I think from a perspective of a system design, you need to contemplate that there could be blockages and that the formal channels may not work the way you intend them to work. Let's talk about hotlines. Again, I see people who obviously are from the community here. I also see law students. But when I speak about hotlines, now this is the 1-800 call-in number, I say, you tell me, do you get calls from people from Eastern Europe? Do you get calls from certain cultures from Asia? And the answer is typically no. What kinds of calls do you get? Well, you might get 1 or 2% of the population base calling a hotline. And when they call, how many of them are fraud and abuse issues? Maybe 1 or 2%. So you got 1 or 2% of 1 or 2%. And what has driven this kind of national phenomenon has been a place for people to report. But it goes to people like Pat, it goes to the general counsel. It's a formal channel. And so I'm thinking this is a mechanism that is ill-suited to how it's being used. Most of the calls are HR. I hate my boss. I got a bad evaluation. Situations that are much more suitable to information, counseling, and some guidance to people. And by the way, many of the hotlines work off a protocol by a third party someplace where they answer the phone for this company here and answer a phone for another company there. And what an ombuds does is give you somebody who is knowledgeable in the people, the culture, the processes, the folkways of an institution. That's the value added that they have, because they can help give you advice and steer you to those places. So with that type of a mechanism, I don't think hotlines are the answer. And there's been a lot of talk about whistleblower laws, Dodd-Frank. Well, the data indicates that most of the whistleblowers tried to raise issues internally first. The National Whistleblower Center says 90%. There's a fabulous article. If you really want to kind of read about this, it's in a context of successful pharmaceutical False Claims Act plaintiffs. A bunch of Harvard public health people interviewed people who got from $100 to $40 million for successful False Claims Act claims. It was in the New England Journal of Medicine of May 13, 2010. You can look it up. And out of the 22 insiders who raised issues as whistleblowers, 20 are no longer employed in the pharmaceutical industry. All of them suffered severe personal issues, family issues, financial issues, health issues. It's not a good thing to be a whistleblower. The government may get billions of dollars, but the individual person puts themselves and their family and their reputation at risk to be a whistleblower. And when you look at the whistleblower laws, there is this huge disconnect between saying you're going to get this bounty and the way it actually plays out. Because the bounty is promised. It could be like Dodd-Frank, 10 to 30% of what they recover. But you've got to make a decision now. And the bounty doesn't come, if ever, until many years down the road. So you've got to decide, are you willing to do this assuming you may get no bounty? Because there's this huge uncertainty in addition to the timing issue. And then, of course, one of the big questions is the fear of retaliation. It's palpable. One of the Ethics Research Center survey questions was, of the people who didn't report, 40% said they didn't report because the person they would have had to report to, they suspected to be part of the misconduct. So what is again, your check and balance for dealing with that? And I think the retaliation piece is often misconstrued at both ends. From a company's perspective, the focus is, what are we training our people to do? What are they responsible to do? And are we engaged in adverse employment actions? And they're right on that. As I say, the world has moved, so there's much more robust training about what you can and can't do. But that's just the tip of the iceberg, because from an employee's perspective, it's adverse employment action and a whole lot more. And by the way, the employee may be wrong about something being retaliatory, but if the perception is that it's retaliatory, it has the same sort of inhibiting effect. And in my slide, I talk about the different kinds of retaliation. And this is my own little scheme, but there's direct retaliation. If I report something, what happens to me? Then there's the under the radar retaliation, which is I report something and there's nothing that I can put my hands on. But the Harvard public health researcher said that retaliation is clearly prohibited by the False Claims Act, but our reports suggest that the protections are not fully effective particularly for insiders. Often retaliation was more subtle than overt harassment. And that's the truth. You don't get an assignment? Is it because you reported, or is it because you weren't the right person? You'll never know. If your boss doesn't say hi to you, what is that? That may mean something, it may not mean something. So it's direct and under the radar. And then there's the indirect retaliation. You report, but I watch you get your head handed to you. Do you think I'm going to report? I don't think so, because there's this kind of cultural wisdom that develops. And then there's the peer retaliation. The company or the institution can't do anything to change that because they're not responsible for it, but it's no less real. We learn on the playground that our peers don't like us being a tattletale, and often that's brutally enforced. So you have the peer retaliation that is equally inhibiting, and then you have what I call the ripple effect. There are nationally publicized cases of Ann Mitchell or Bobby Maxwell or Cheryl Eckert. Those are all big whistleblowers in the last year or so. And all have gotten national publicity. And every time you hear about those, you think to yourself, good Lord, whistleblowers really do get screwed. They really do. And by the way, whistleblowers come in all shapes and sizes. Some are nuts and some are not nuts. Some are nuts and correct, and some are not nuts and not correct. And so the problem is, how do you sort that out? And I think the answer is you need some help with information, and you need some guidance. So I'm going to end with just some quick conclusions here. They don't teach you this in law school, but you heard it here. The law cannot protect you. I don't care what the whistleblower policy says. I don't care what the company's policy is. Human nature does retaliate against people, and the law really can't protect you. Compliance policies, hotlines, whistleblower laws are all good and I think necessary, but they're not enough. You need checks and balances in your system, and you really need a place to be able to get guidance or information before you start that machine that's going to grind up the process, before it begins the investigation. And you can't get that through some of these formal channels. If you are set up to be independent, neutral, confidential, then you have a good argument to be made for how you can be confidential. And the confidentiality is the key, because people need to be able to talk off the record and informally. And I think that's what an ombudsman does. So that's kind of what it is in a nutshell and why you might have it. And Pat will give you the context of the overall compliance policy and how it fits in there.
Little did I know that when I was called to the general counsel's office, I was the associate general counsel for litigation at United Technologies Corporation, and he said, the ombudsman, our new ombudsman, wants to know how you're going to protect him if he gets sued. Little did I know that I was going to help Chuck build and write this book, because Chuck is who I called back in the 80s and said, we've got to figure out a scheme, an ability to protect the ombudsperson. And since then, he's made a whole career out of this. You owe me something, I think.
I still have another day job.
I've been with two companies that have had ombuds people, and I believe in it. And I believe in it very strongly because my primary role in both of those corporations was as the chief ethics and compliance officer. And I was responsible for, in effect, maintaining the integrity of the corporation. Not for the benefit of management, not for the benefit of the employees, but for the benefit of the shareholders. That was my role, that was my responsibility. The ombuds person and the ombuds function is a piece of an overall integrity program. The way I like to describe it is that we don't like to talk in terms of whistleblowers because we don't want to make anyone a whistleblower. It's a very negative term. And a whistleblower is someone who doesn't get listened to, doesn't get the information that's necessary, doesn't get heard within the corporation. And therefore, they have to go somewhere and they have to blow the whistle. We want to encourage people to communicate. And what we want to talk in terms of is a corporation or an organization having an open communication program. I remind board members whenever I talk to them in my role that they need to set the culture for the organization. The culture needs to be set by the board, not by the CEO. And I've heard so many times people say to me that the CEO sets the culture. Forbes magazine shows you that CEOs, on average, last 4.4 years. Well, if that's the case, And if CEOs last 4.4 years, the culture is going to be whipsawed back and forth constantly by an individual who has a different attitude with respect to open communication, to integrity. I've heard CEOs say everybody is honest. Well, that's a great term. Everybody is honest. My grandmother was honest, and she prayed all the time. My mother worked outside the home, and my grandmother took care of me. My grandmother bootlegged during Prohibition. Because in her mind, that was okay because she had to feed her family. I came from a corporation of 215,000 employees, 90,000 of which were U.S. citizens. The rest were foreign nationals. We were in 180 countries. Americans were no more honest and no more crooks than any other individual in any other country. Human beings have amazing capabilities. John talks about boards saying what keeps you up at night, and I talk about the enjoyment of waking up every morning and finding out what another human being has figured out in the way they break the system. Because they do. They have great imagination. And for those of you that believe that everybody wants to do the right thing, you're wrong. Everybody doesn't want to do the right thing. I would love to tell you that that's the la-la land that we live in, but we don't. There are people that want to do the wrong thing, and they will either dictate to other people to help them do the wrong thing, or they'll do it themselves. If they do it themselves, it's going to be cheap on the company because they're just breaking, they're cheating on their expense report, or they're cheating on their travel, or whatever it is. It's small. But when they want to have a big conspiracy, they need others. They need others to help them in that conspiracy, and they will threaten them, or they will force them to do it. If you don't have an avenue within an organization that individuals can come forward, and it's just one piece of it, but the ombudsman is a piece. It sets the tone. It says that management cares and wants to give you an avenue that you can come forward and talk to them on because the ombudsperson is a neutral. As the Chief Ethics and Compliance Officer, I'm management. My responsibility is management. My responsibility is to investigate. My responsibility is to, in effect, recommend disciplinary action with respect to individuals. My responsibility is to manage a program that talks about integrity, and the ombuds piece is a huge, huge piece of telling your employees that we care about you, and we care about you, and we care about what you have to say. Now, I will tell you, there's a great upside to an ombuds person besides an ombuds function, besides just the fact that an employee can go forward. If you actually believe in an ombuds program and you actually work it within an organization, managers know that that employee has a place to go to complain about being forced to do something. That's a deterrent right there. In order to do a conspiracy, you have to force people or you have to get people to cooperate with you. And you never know whether one of those employees is going to pick up the phone and call the ombuds person. Normally, Chuck is right. They're not normally going to call a hotline. Because what happens with hotlines, unfortunately, is hotlines are manned by individuals in South Carolina or in Georgia or in Iowa, and they've got 100 phone lines. And they answer the phone, Procter & Gamble, General Electric, United Technologies Corporation, and all they do is take down exactly what the individual says. They don't ask questions. They take down what the individual says. I just helped give advice to a company that had to put in a hotline because they were under an administrative agreement with the government. And so they put it in, and what I wanted to do was test the hotline. So I developed 5 questions that I had employees within the company call at various times during the period of the week. Some at 6 in the morning and one at 12 at night, just to make sure that the hotline was working and it was accurate. Of the 5 questions, 3 were exactly the way I had written them. One was half of what I had written, and the fifth one, I couldn't even understand. So as played back to me, no value. No value whatsoever. Ombuds people are trained to ask questions, to delve deeper. Chuck talked about this earlier today, about somebody walking in the door and saying, can you tell me where I can see the corporation's policies? They're not really asking where do you see the corporation's policies because they know that. An ombuds person knows enough to ask more questions like, what specific policy would you like to know about? Do you have a concern with respect to a policy? Can I help you with respect to interpreting the policy? That's what we train ombuds people to do. They help with conflict resolution all the time. And so if you're talking about wanting to work for an organization, you want to work for an organization that has integrity, and you want to work for an organization that sees integrity as being an organization that wants its employees to feel comfortable about raising issues. Whether it's to the ombudsperson or to HR or to the chief compliance officer or anybody else in the organization, if you develop that kind of organizational structure within a company, I guarantee you, you don't need whistleblowers. You won't find whistleblowers because whistleblowers are not people who sit down and think about it. And I will give you the best example I can. If you just read what happened recently with respect to the Bank of New York and Mellon, that whistleblower had planned to be a whistleblower for 2 solid years. For 2 solid years, they sat there and they took in information intending to be a whistleblower. Most people don't work in corporations thinking that they're going to be a whistleblower. But when they find themselves in a pressure situation, when they find themselves in a situation where they have to do something that they don't believe is right and their gut bothers them, they need a resource. They absolutely need a resource. And the resource, the best resource I've found is the Ombuds resource, because these are individuals who make sure that people get resolution to their problem. They're not management. They are neutrals. They don't take management's position, and they don't take the employee's position. What they do is they take the employee's issue, and I'll end with this. Hotlines are anonymous because somebody walks in, calls up on the phone, and doesn't give their name. That's an anonymous phone call. And there's not much you can do about it once the person hangs up. Because if you can't ask them more questions, if you can't delve into it more deeply, you're sunk, and you hope that they call back. Ombuds people develop a relationship and give anonymity to an individual. Not anonymous because the person comes in face to face. They could call, but they do come in. And then it's no longer anonymous for the ombudsperson. What they do is they maintain the individual's anonymity and don't, in effect, ever give that name out. Chuck has spent a whole career, well, the last 20 years of his career, defending ombuds people for not having to give that information to a judge or in a courtroom. And what it comes down to in the end is, if a company does its job and somebody comes to the ombudsperson and the ombudsperson makes sure that the issue gets resolved, that means that somebody in management has to resolve it. HR, the corporation's legal department, the chief compliance officer, our files are discoverable. And that's really the issue. And so when you say to the judge, why do you need this ombudsperson to tell you the name of the person that brought it forward? The issue is there was bribery. The issue is there was kickback. That's the issue. Here are our files. Here's the investigation. Here's what we found. That's the issue. Not who brought it forward. That's irrelevant. But you're going to break our confidentiality that we promise our employees that we're going to give them. Thank you very much.
Well, we're happy to take questions. So, yes?
I'd like to hear the perspective of the ombudsperson's relationship with the audit committee chair, assuming you've got the internal audit reporting directly into the audit committee chair and the ethics point hotlines feeding in to the audit committee chair. How do you work the relationship?
Well, let me, sure. The question is, what is the relationship between the ombudsman and the audit committee chair? Have I basically got it right? Okay. Typically, the ombudsman reports to a senior person in management. They're structured independently. They have a charter. They have an employment contract that requires them to practice in accordance with certain code of ethics and standards of practice. And they have a dotted line access to the audit committee chair. And one of the great advantages to an organization for having an ombuds program is not only does it do double duty in terms of conflict resolution, but helping guide people to how they can report misconduct, giving them options and explaining the process. But they also do statistical trend analysis. So they would not reveal confidential communications, but they would track, how many people are presenting with these kinds of issues. Not that they're determining by virtue of an investigation the truth of those issues. But you can tell a lot when you see certain types of issues coming forward that may reflect, and I think Pat has some insight into this, certain issues of management or the way the company's been described. If it doesn't get resolved internally with the company, the good ombuds programs are structured that they have access to the board. I think John would tell you that the board should be part of that process from the get-go, where the ombuds is doing that trend analysis report to the board.
I want to take the other side of that, because I have a conviction, a personal conviction over 7 years of listening and investigating this, that the presence of an organizational ombudsman is one of the most powerful governance tools a board has at its disposal. And precious few board members know what an ombudsman is. Fewer can pronounce the word. And almost none has any concept of how it relates to governance. I think that done right, the ombudsman would report the direct line to the chair of the audit committee with a dotted line somewhere into management, because it's not particularly well understood yet, and the whole process is a work in progress, even though it's 20 years old. How to say it? If the ombudsman reports up through management, it's very hard to differentiate in people's minds. This is really separate from. If it reports around to the board gets unvarnished, unfiltered access to what's going on. And if done right, again, the budget, I say, would be in the governance budget. In good times and bad times, that budget doesn't fluctuate. If it goes up through one of the administrative and line side in management, and there's a bad time and there's across the board 7% cut, the ombudsman might be perceived as a cost center. Out it goes. That doesn't help the board that I think needs to know what an ombudsman.
John, just, I think your question is more mechanical in the sense that
No,
what.
it's not mechanical.
Okay,
It
no,
is
but I meant
actually-
is what.
Because I'm a very strong believer that tone at the top is
Right.
set by the board.
Okay.
And the audit committee chair is very responsible for.
No, what I meant by mechanical is what's the process with respect
No,
to.
he answered it.
Okay.
I would say I would have a direct report. I would have the
Right.
ombudsman report to me as I would IA.
Okay, but the ombudsperson is not bringing issues to the board. The issues that are brought to the ombudsperson goes to management, and management needs to resolve every one of them. Therefore, issues that come to the ombudsperson have to be resolved by somebody in management. What the board wants to do is protect the ombudsperson and hear from the ombudsperson that they have total access, absolute ability to do their job, never asked who the names are and who came into them, and what are the kinds of issues that you're getting, because the issue gets investigated by either HR, by the legal department, by the compliance organization, and those are who report to the audit committee. We had this kickback, and they're not reporting where did we get it. We had this kickback, we investigated it, it occurred, we fired 7 people, this is how it happened. That's who's reporting the actual action, because the ombudsperson is the one who brought the issue forward to either compliance or to legal. But what boards do is protect the ombudsperson and know that the ombudsperson has free reign, is doing what they are able to do, has the kind of staff that they need to have, and that they get the support from management that they have to have.
Other questions? Yes.
Yeah, so who's responsible for ensuring undue influence? Is it a closed session to the board members? Is it management? And then approximately what type of level is this type of position?
So the question is, who's responsible for undue influence, making sure there is no undue influence? And what was the second part?
And at what type of level is this person?
And at what type of level is the person? The undue influence question arises in terms of the structure of the program. The good programs have charters that guarantee certain things. There are places where boards adopt resolutions to create these offices. And then they have access to not only senior management, but in the best of circumstances, it doesn't happen everywhere, to the board. The level of the person is one of the big challenges, because One of the things that I have seen in places is just what John said. And it's the same with compliance officers. There can be this kind of erosion over time, the devaluing of the function once it is up and running. So the best programs pick somebody fairly senior. Often it is somebody who's highly regarded in the culture, who can speak to the janitor, who can speak to the CEO, who's steeped in the culture and who's known by everybody as a straight shooter. That's almost more important, reputationally important, than the training. You can go to various programs and get the mediation type training, but the credibility is key. And I think it should be a senior person. It is something of a thankless job because it is listening, talking, helping people sort out issues, counseling. And for some people that is a wonderful thing to do, but it does require having everybody dump their buckets on you every day as you listen to this and help people through it. And the really big organizations, and I've worked with a bunch of multinational organizations, will have 4 and 5 of these people, sometimes located around the world, usually with different genders, different races, different skill backgrounds, because not everybody will be able to connect. Even if they don't see each other face to face, they will talk on the phone. So I think you need a mix of people. Again, the theme is, what are your checks and balances and how are you developing multiple avenues for information to percolate up?
So is it the role of the ombudsman to coach the reporting party how to go report effectively? Or is it the role of the ombudsman to take what they hear and then go report it themselves?
It may be a variation. It could be coach the employee to report, or it could be to take what the employee has brought forward. If they can do it without having to identify the employee and get it over to the right organization to do the investigation, it's not important who the individual was. So you don't always have to, what you're doing is trying to protect the individual. So to have them report it, in effect, the anonymity is now gone.
But in virtually all cases, the employee retains control over what happens. So if the ombuds would lay out options, would help frame or sort issues, but ultimately the employee would decide, go forward or not go forward. There are a few instances where the employee would authorize the ombudsman to take an issue forward on their behalf. When that happens, the ombudsman is kind of in a little dangerous territory, and that would be a notice event to the company. But often it can be packaged in a way that what the employee told the ombuds is not necessarily what the ombuds then conveys. So it can be managed in a much better way. And then in cases that came out of California, I don't know, I assume many of you are law students or lawyers, there's the whole Tarasoff line of cases that if there's an imminent threat of serious harm, regardless of how you set up your program, that if it's identifiable third parties, you have a duty to report. The law will impose that duty on you to report. So you may have to break confidence in those cases.
Well, and so I'm struggling a little bit, I was a chief auditor and ran the hotline and, always, the anonymous things would, people would go through the hotline and they may come to you directly and you always have to protect their confidentiality and then no retaliation. So I'm a little bit puzzled here, and so then, of course, they bring it to you and dump the bucket, as you say, and then you have a duty to put down your pencil and go investigate. But if you're the ombudsman and they say, oh, I just wanted to talk to you and I don't want this to go any further.
This is where the training comes in,
Yeah.
because these individuals are trained to work them through the issue. It's just like the individual. I will tell you the classic example is the woman who walked into our ombudsperson and said, I'm being sexually harassed, but I just wanted to talk to somebody. That ombudsperson talked to that particular individual for 4 weeks, and over a 4-week period convinced this person that they had to come forward to prevent it from happening to other people. But it took someone who had the patience to do that and not have to blow the whistle because they were below the line. They weren't management. And so they were able to convince the individual to come forward. But you need that kind of an individual who has that capability.
And this gets back to Pat's point, anonymity versus anonymous. The ombuds can be proactive in the sense that they can seek out people, they know who they are. They can't make them come forward, and ultimately they may not come forward. But by laying out options, searching for ways, what is the concern if you were to come forward? What is your biggest concern? Well, let's see if we can find a way to surface your issue but address that concern. That's the mediation, that's the counseling, that's the skill that they
But
bring.
you still could be left at the end of the day with, I know something bad is going on, bribery, fraud, whatever. I know it, and they don't wanna come forward, and
Well,
what do I do?
That could happen. I'm not gonna say that couldn't happen. It could happen. But think of it this way, for every time that happens, there are gonna be lots of other times this counseling option process surfaces those issues. And you're never gonna capture it all anyway, all the time. It's just never going to happen. And if that's your standard, then we need to do something entirely different, because you'll never get to that standard. And that's the problem with the formal channels, because they can only deal with what is brought to them. And the question is, because they have to then deal with it, people won't come to them.
But to go further, it's not gonna happen. I'm much more the optimist than Chuck is, because the ombudsperson is trained and works the team to figure out how we're gonna get this forward. I'll give you the example of the secretary who says her VP boss is cheating the company on his expense report, and she's the only one that knows it. And they go to the ombudsperson and wanna know, it's bothering me, but I can't do anything about it because I'm gonna get fired. And they bring in the chief compliance officer, who the individual says, okay, I'll talk to the compliance officer on the phone. And the compliance officer says, if you tell me where it's happening, I'll order an audit of every vice president in that organization of their expense report. No one will ever know that we were pinpointing one. When I did that, I not only found that individual, I found 2 more vice presidents that were cheating the company. All 3 were fired, and that individual never came to light. Didn't need to. But we need to be able to show them that we can do these things without having to blow the whistle and say it's so-and-so brought it to our attention.
Well, what is really attractive to me is that there is somebody that they can talk to, because it filters out, as you know, the hotline gets about 90% nonsense, and so it filters out the nonsense and feels like.
Yeah, but sometimes that nonsense is a test
Yeah.
to see how you're gonna react to it.
Next question's in the back row there, second one in. Yes, you.
Yeah, for a small to mid-cap company, do you recommend the same structure when you don't have the resources to have 5 people and a full-time person?
I'll speak to that, and there is some controversy about this. Ideally, a large corporation can afford an inside person who knows the culture firsthand. Terrific. Small organization that perceives can't afford it, either can't have an ombudsman or have an external contract ombudsman. There are people who do that for multiple different companies. You can make an argument of independence much more clearly than for the inside employee. The other side is, but they don't know the culture as well. I've 30 years made my living representing companies. If I went to find a new CEO for them, I had to know that culture to a certain level. I couldn't get away knowing less. I didn't have to know more. Where is the threshold? My job, find it and get there quickly. I say a contract ombuds can do the same, but there are clearly trade-offs. Yes.
To that point, we have a very small company. We don't have an ombudsperson, but I can see the benefit of it. And to my mind came somebody who's retired from the company, who's doing a lot of other things and non-profit kind of things. And I could see in a minute hiring him for X hours a week because he knows.
Great concept.
Yeah.
Great concept.
And if it fits the profile, everybody top to bottom thinks this person has integrity, that can work. That can work.
Yes, sir.
Is it fair to think this person is sort of a lay clergy?
Oh, please.
On a wing and a prayer.
Well, I'm just looking at it. If you look at the role of communications, clergy plays a special role. The communications are confidential. They're rooted in the community. They seek to create solutions that are effectuated by the persons involved.
But the ombudsperson doesn't pontificate.
Well, good clergy.
But I've often said that it's very similar to a ministerial role. And, many of the people who do this are former social worker MSWs. They're actually people, I was with one last week that described themselves as a recovering employment lawyer, who found that after all of the battles, this sort of collaborative problem solving, and you know, having a legal training is a terrifically good asset, I think, because you now see, you see all of the elements of the employment, the corporate governance, the criminal, you see it. But it is a job of everyday talking to people.
And the law has long recognized the need for confidentiality in that role, probably for precisely the reasons that organizational.
The only reason the only reason I bristled is because it's really hard for me to convince management that they need clergy in their business. So I only bristle in that regard and say that our ombuds people are trained to be conflict resolution people. I mean, they're really trying very, very hard to diffuse.
The role of this person is not to be moralistic.
Right.
Yeah, to be
Never.
neutral, and also,
Yeah,
just speaking as, again, sort of the proxy for the layman, the non-attorney here. I remember one time going into a company, I was gonna go in to talk to the vice chairman of the bank. And I went into the lobby, got in the elevator, pushed 12, because that's where the office was. And about 4, door opened, young woman stepped in and went to push the button, and her eyes got bigger, and she turned around, they were the size of saucers. You're going to 12. I was there once. Wow. And then she pushed 7 and got off at 7. I went up to 12, stepped off the elevator, and here's a floor the size of the state of Connecticut. And down here is an office the size of the state of Rhode Island, the CEO. And here's an office the size of Delaware, the executive vice president of human resources. Down here, the vice chairman. Talked to him about this function, the ombudsman, how important. He says, well, you know, the chairman says to the employee body, my door is always open. You can come on up anytime and tell me whatever's on your mind. And our executive vice president of human resources, wonderful guy, avuncular, everyone loves him. His door is always open. We don't need an ombudsman. Now, ethics, compliance, internal, he was saying we don't need an ombudsman. And I said, no, you misunderstood. You need an ombudsman. It cuts across all those functions and creates a context for all of them to work better. So you don't need a clergyman, you need an ombudsman.
We had a comment from actually an ombudsman here, and how are we doing on time? Are we? It's just,
Five more minutes.
okay,
Just
Martha.
quickly, I think you have to look at the culture of your particular company and then pick or choose someone that fits that culture, like your idea is great. And also style the office in that way so that, you know, maybe there are companies where lay clergy would be appealing, you know, a diocese or something. But, you know, in others it wouldn't
Right.
help. But I think that I got my job as the ombudsperson in medical school because I was a healthcare lawyer. And I worked as a healthcare lawyer in the hospital. And that was very helpful to make that transition. So someone within is usually good.
Yes.
So do you have a sense of how many high-tech companies have ombudsmen in this area? And secondly,
Zero.
Okay.
Not many, not that I'm aware of. They move too fast.
They
Well-
use IA,
They
they
use
have,
IA as, a lot of what you're saying, IA does.
or
Right.
they have the
You
office.
can't.
IA meaning internal audit?
Internal audit.
Yeah, or
Yes.
they have ethics and compliance
Right.
functions.
Absolutely, they have those functions.
And so, and what is the relationship between an ombudsperson and ethics and compliance and legal?
Teamwork.
As far as teamwork, so that, does the ombudsman sort of like report by himself or herself?
They may administratively sit somewhere, because usually everybody has to have some kind of an org chart where there's an administrative function. But the last thing you want is an ombudsperson who has to report to an organization or an individual about everything that comes into their door. You just don't want that. They have to be independent. So they can be administratively under this or that or anybody else. You want them to have direct access to the board. You want them to come to audit committee meetings. You want them to be able to go into executive session and say, I have no pressure on me, people are responsive, management is responsive. The board needs to hear that, but they need to hear that in executive session. So there's no management around.
And actually, on a larger scale, what's your sense as far as, you know, corporate America ombudsman? Because I don't get the sense that there are many ombudsmen. It's more ethics and compliance officers.
Oh, I couldn't agree with you more. What happened in 1991 with the federal sentencing guidelines, they created a minus 3-point deduction for having an effective program to prevent and detect violations of law, and that drove the creation of the compliance industry. That's a long analysis, and now it's a worldwide standard. There is no natural constituency that's advocating for an ombudsman, because the compliance think they can do it, the HR think they can do it.
I don't think I can.
Well, many compliance people think they can do it. And so it is this odd concept that has begun to evolve over time. But you asked about high-tech companies, and I think there really aren't any that I can think of, but there are a variety of companies that I've worked with, National Defense Labs, universities that have a high scientific technical component, engineering organizations, financial organizations, companies that I would describe as having lots of technically trained scientific, engineering, financial type people. And one of the statistics that I've checked across a whole variety of these that astounded me, frankly, when I first heard it, and which is why I tested them, probably about 35% of the inquiries that come to the ombudsman in those types of environments, sophisticated workforce, highly technical, professional, highly trained, were from first and second tier managers. They weren't from the kind of rank and file employees. They were people who had managerial responsibilities, were troubled. They had been promoted because of their technical competence. They probably didn't have the soft skills of management and understanding all of this. And they were looking for ways to help solve problems. And again, it's off the record, it's confidential, and that's why they sought out the ombuds.
Don't you think that in some ways, an ethics and compliance function that's structured so that it does look independently at issues that are raised to it, can combine, can function as some of the,
Every time you say ethics and compliance, say police. Say police, because that you're looking at it from the top side down. Think of it from the bottom side up. You have a job. Ethics and compliance has a job to do. There are people who will come. Yes,
We have a nice term, but you have to think of us as IGs. We are inspector generals for the most part. I mean, our job is to root it out anywhere, any place. And individuals who come forward and tell me about somebody violating the Foreign Corrupt Practices Act or somebody doing a kickback, they need to know that I'm going to jump on it right away. And I have to tell people that I'll try to maintain confidentiality. I can't guarantee it. But I can guarantee it through the ombudsperson, and we can work it. So, no, I'm the police officer. That's my role.
One more question? Okay.
Much use of this in government, and I'm wondering how the applicability of, like, say, Public Records Act.
Well, actually, I've written on that. I've worked with organizations like NIH, and I know there are other government organizations that have this organizational. The question is organizational ombudsman in the government, and there are several organizations in government that have them. And you've put your finger on exactly a very tricky question, the Freedom of Information Act, open records. And I actually have a section in the book dealing with that in the governmental setting. I've also worked with state universities that have this, worked with MD Anderson, which is as part of the University of Texas. And those are very tricky questions, and it often involves not creating records. Because once you create the record, it then becomes very hard under most of these Freedom of Information Act and record retention statutes to destroy it. So in those types of organizations, it's a tricky, unsolved question. But the amendments to the federal Freedom of Information Act, there's a ADRA, Alternate Dispute Resolution Act, that actually creates for the federal government a balancing of interests for purposes of disclosure, and ombudsman is specifically referenced there. So there is that mechanism available.
Maybe one last question.
Yeah, in light of Dodd-Frank and the fact that we've now incentivized bounties or rewards to whistleblowers, what are the implications of that relative to ombudsman?
Well, I kind of went through this a little bit earlier, and I know you came in a little bit late, but that's all right. Essentially, the Dodd-Frank requires to get a bounty that you have original information, that SEC recovers more than $1 million. It requires you to file your report with the SEC. And I think the data shows that most people don't want to become a whistleblower. They've got to make a decision with no assurance that they ever will be. If they ultimately get a reward, it will be at the SEC's discretion as to whether it's 10 or 30%. And that bounty is not really motivating people, I think, to do that. It's too uncertain and the timing is all wrong. And I think people still feel the personal effects of retaliation.
But just one point. Those of us that have been doing government business in our corporations for years have been under the False Claims Act, where qui tam plaintiffs can bring things to court and do that. And so we don't see any rash change with respect to Dodd-Frank. It just opens it up to the commercial world a little bit more. But individuals can go forward anytime, any place, anywhere to the SEC or to the Justice Department. The bounty is not guaranteed. Just isn't. And neither is the qui tam. It's not guaranteed.
And I want to add one thing to that. We talked about the ombudsman as setting a context, hopefully a culture of trust. If you think about sort of conflict resolution as a continuum running from 1 to 16, whistleblowing happens around 14 and a half or 15 and a half. And basically, whistleblowing is someone desperate picking up a bright orange, plastic thing, and why? Because they couldn't find a voice. There was no culture that supported them being listened to. They're desperate. Their health and finances go to pieces, the statistics say. The ombudsman happens about 1 or 2. If you have an ombudsman there that helps set a context of there's a safe place to go to reveal I think maybe not good stuff, you never have whistleblowers because it never occurs to them to blow a whistle because they had a safe place to speak within a culture of trust, and it got resolved.
Let me give you and we'll end on this if it's all right. I mentioned earlier, I think maybe before you came in, if you haven't taken a look at the New England Journal of Medicine article of May 13th, 2010, it's a study of 26 successful False Claims Act plaintiffs in the pharmaceutical industry. 22 of them were insiders. 20 of those 22 were no longer employed in the pharmaceutical industry. All kind of regret ever blowing the whistle. All ultimately did it for ethical, spiritual, moral reasons, and it wasn't worth the candle, even though they all rang the bell and got a recovery. But for the book that I did, I found a study from 1999 of 300 whistleblowers. And when you think about what motivates a whistleblower, virtually everybody, as common understanding, thinks they get screwed. But here's what the whistleblowers themselves reported. Severe depression or anxiety, 84%. Feelings of isolation or powerlessness, 84%. Distrust of others, 78%. Declining physical health, 69%. Severe financial decline, 66%. Problems with family relations, 53%. There is a toll. There's a toll on the individual. It's personal or financial. It deals with all of your relationships with your friends and with your families. Being a whistleblower is the last thing most people want to do. And as John said, they do it out of desperation. I think there's a gap, and I think that the Organizational Ombudsman helps fill that gap and helps people resolve conflict and know how to come forward. So thank you very much for having us.